Hi, I'm immigration law attorney Mark Christopher. I'm here to answer a very common question that gets asked in my office by many of my clients. The scenario is the following. A parent comes into my office. They tell me they've been in the United States for a long period of time, but they don't have legal immigration status. However, they tell me they do have a child and that child's about ready to turn 21. The question is, can the child petition for the parent? And if they can, whether or not that parent will be able to become a permanent resident based off of that petition. Let's analyze that question. The first question is, can that child petition for the parent? If the child is 21 years old and the parent is the biological parent, in almost every instance, that child would be able to petition for their parent, whether it's father or mother. Also, a U.S. citizen child, age 21 or over, can also petition for a step-parent if the step-parent relationship was established prior to the child turning 18. So in other words, if mom marries stepdad prior to that child turning 18, then yes, that U.S. citizen child will be able to petition for their step-parent when they turn 21. Now, the second part of the analysis is much more complicated and in-depth, and that is whether or not the parent would be able to become a permanent resident. Now, process-wise, there are two ways to go about becoming a permanent resident. The preferred way is the adjustment of status. That is where the complete process takes place right here in the United States. The other, less preferred way is the parent is required to go back to their home country and go through what's called the consulate process abroad. That always brings up additional issues and concerns. So let's find out who's available and able to do an adjustment of status. In order to do an adjustment of status, the first question I always look at is, and I ask my clients, is how did you enter into the country? Did you enter in with inspection, or did you enter in without inspection? With inspection, did you come in on a tourist visa, for example, and simply overstay your tourist visa? Or perhaps you were in the United States and you received deferred action and you did a request for advanced parole. That's where you leave and then come back into the United States. In those instances, you are eligible to adjust status here in the United States, provided that there are no other grounds of inadmissibility, such as multiple entries or criminal issues. Now, if you did not come in with inspection, it gets much, much more difficult to adjust status, but there are a few narrow exceptions. The narrow exceptions are the following. Number one, were you ever the beneficiary of a petition filed prior to April 30th of 2001? Or were you the derivative beneficiary of such a petition? How would that come into play? Let's say, for example, you have a United States citizen brother or sister. They petitioned for you back in, let's say, 1998. Even though that petition from that sibling is not yet mature, you can adjust your status in the United States even if you came in without inspection based off of the petition from your United States citizen child. I know that's a complicated explanation, but it simply is this. If you're the beneficiary of a petition filed prior to April 30th of 2001, and you now have an immediate relative visa available, then you can adjust status in the United States. The second exception is whether or not you have an immediate relative who is currently or has been in active duty military. So in other words, perhaps that child that's petitioning for you is in the Marines or in the Army, or perhaps at one point you were married to someone who was in the United States military, or maybe your parents were in the United States military. In that case, you can apply for what's called parole in place, which acts as an admission with inspection, and you can adjust status right here in the United States. Now, if you don't fall under one of those exceptions, you are required to go outside of the country and go through the consulate process. The big problem with that is if you have accumulated more than 1 year of unlawful presence, which almost everyone has in this scenario, when they leave the country, they're going to be required to wait 10 years outside of the United States. How do you get around that 10-year wait? Well, there is something called a waiver. A waiver applies to anyone who can show an extreme hardship should they be separated from their spouse, who's a permanent resident or citizen, or parent, who is a permanent resident or citizen, for a period of 10 years. Notice the law does not take into account an extreme hardship for the child, the U.S. citizen child. It's only spouse or parent. So I ask my clients, if they're not married to a permanent resident or citizen, do they by chance have parents who are United States citizens or permanent residents? Many times the answer to that is no. And if the answer to that is no and they entered in without inspection and they don't fall under any of the exceptions, yes, the child can petition, but unfortunately there's not a lot of benefit to the child petitioning for them because they can't become a permanent resident without waiting outside of the United States for a period of 10 years. So I understand that that's a very complicated explanation, but I think it sheds some light on a very common problem that we have with my clients. In other words, their child turns 21, but they're not able to adjust their status or become a permanent resident based off of that petition. Again, thank you for listening. Please contact our office, Christopher Law Office. All immigration cases are different. All deserve and demand detailed analysis from a reputable and experienced immigration law attorney. I thank you for watching.